This is, welcome, first of all, everybody. I'm reading 64 people out there, so the numbers continue to be pretty good. This is the 6th, I believe, of a number of scheduled sessions that the Department of Labor is conducting to help folks understand the earned paid leave law that goes into effect in January. If you recall, you might recall that we have been holding a series of listening sessions and doing rulemaking and holding hearings and responding to comments over the last roughly a year and a half. We finally published our rules interpreting the statute, implementing the statute last September, and now our commitment is to help everybody that needs to understand to the best, the greatest degree possible, how this new statute will be implemented and enforced by my bureau, the Bureau of Labor Standards at the Maine Department of Labor. So welcome, I'm Mike Rowland. I'm the director of that bureau. With me also is Scott Cotnor, who is our wage and hour director, who will be providing most of the information and responding to most of the questions that you're going to be hearing. With us also is Christina Starr, running the show, our coordinator of outreach and education, thankfully. And others, I don't think any others here from our bureau, but from another bureau in the department, the Bureau of Unemployment Compensation, we're joined by Jeff Brandt and Michelle Cowperthwaite, both of whom are tax auditors in that bureau, and they're here to help us explain those sections of the statute that refer to the Employment Security Act of Maine, of which they are the experts. So the little bit about procedure, we're all starting out muted. Scott's going to give a brief PowerPoint presentation explaining the basics of the statute. Then we will respond, Scott will respond to your questions, which you can submit via the chat feature. I bet everybody's familiar with that by now. Even I am now. And or you can raise your hand virtually and Christina will unmute you if you prefer to ask your question verbally, or if you're on the phone, perhaps. So we are recording. I want everybody to know that. I think Christina mentioned it. We're recording this session. Hopefully we'll be posting one of our sessions online so that other people can access it. Other than that, I'll let Scott take it over and I'll see you in a little while.
Yeah, thank you, Mike. All right, so what I'm going to do is share my screen. So bear with me while I set that up. This takes a moment here. All right, hopefully everybody is seeing the first slide of the PowerPoint presentation now. All right, so earned paid leave. Back in May of 2019, Governor Janet Mills signed the earned paid leave law after spending a lot of time and working with a diverse group of stakeholders to create a consensus to support Maine workers who lack any type of paid leave. The law is going to go into effect January 1st, a little less than a month and a half from now. As of January 1st, 2021, all employees, eligible employees, are going to start earning 1 hour of paid leave for every 40 hours that they work. And they'll be able to accrue up to 40 hours of leave in a defined year. This law is going to apply to most businesses who employ more than 10 employees in Maine for more than 120 days in a calendar year. Employers will be able to apply a 120-day wait period before they're required to allow new employees to use their accrued earned paid leave. Employees that have been employed for more than 120 days as of January 1st, 2021. So your existing employees now, if they've worked or have been employed for more than 120 days as of January 1st, 2021, they'll be eligible to use earned paid leave once it's accrued. Earned paid leave can be used for any reason, such as an emergency, illness, sudden necessity, planned vacation, anything along those lines. Once the law passed, we had to create, as a department, rules as to clarify the law and add clarity to the law and rules for enforcing. Within those rules, we had to come up with some key definitions of terms that are used in the law. So basic definitions are a 1-year period is any period of 365 consecutive days. In the case of a leap year, it's 366 days. 120 days is calendar days. It's not 120 business days, and it's not actual days worked. Emergency or sudden necessity are terms that can be used interchangeably. It's basically a situation in which the need for leave is not reasonably foreseeable. Also used in a term used in the law is undue hardship. This term is also used in another law, which is the leave for victims of violence, and already has an existing definition in those rules as basically a significant impact on the operation of the business or significant expenses, considering the financial resources of the employer, the size of the workforce, and the nature of the industry. Start of employment is the first day an employee performs work for the employer. So I like to give an example of an employer that's having an interview, holding an interview to fill a position. They like the candidate, they offer that position to the person being interviewed, that person accepts the position. During that interview, the employer asks that individual, after they've accepted the position, to complete paperwork before they leave. That is going to be the start of their employment, the first day that they performed any work. If they have the individual fill out paperwork, employment paperwork at that point, that's the start of the employment. If the individual says, I can start work in 2 weeks, and the interview ends, no paperwork is filled out, when that employee reports to work in 2 weeks and starts any type of service for the employer, that's when that will be the start of employment. Another term is the calendar year. That's basically January 1st through December 31st of any year. Seasonal industry is also used in the law. And basically a seasonal industry is an industry in which, because of its seasonal nature, it's customary to operate only during a regular recurring period or periods of less than 26 weeks in a calendar year. If you have questions, if you're a seasonal employer or not, you should call our office so we can research that for you.
Hey there, Scott. Just wanted to give you a heads up that the screen is showing that next slide screen that sometimes happens when you're sharing your displays. It's not just the one large slide.
All right, so let me see if this works. Is this any better?
Still the same. Oh, nope, we're good.
Okay. All right, who is covered by earned paid leave? Covered employer is an employer that's defined. So the law specifically states that the definition of employment, an employer, and employee are pulled from the terms defined in the Employment Security Act. So this particular law section, 1043, So covered employer is defined in 1043, who employs more than 10 covered employees in the usual and regular course of business for more than 120 days in any calendar year. That 120 days is not consecutive days. It's any 120 days over the course of the year. A covered employee is a person engaged in employment for a covered employer, except otherwise set forth in the Act. So it's not going to include seasonal employers. A covered employee may also include, or may include a person who's employed full-time, part-time, per diem. Their designated status is not a deciding factor. Okay, so if the work is deemed covered, covered employment for a covered employer according to the Employment Security Act, and there are more than 10 employees, then they're going to be covered by the earned paid leave law. Again, if you have questions about if you're a covered employer or if the work being performed is covered employment, please call our office, because we'll ask, we'll get the specific facts or details in your case and be able to make a determination for you. There are exemptions to this law. The law is going to cover approximately 85% of Maine workers. Exemptions include businesses with 10 or fewer employees in Maine, properly classified independent contractors. Now, I say properly classified because there are a number of businesses that may have, maybe paying individuals a 1099 and paying them off the books and giving them a 1099 at the end of the year, but they don't actually meet the independent contractor or employment standard. There is a standard used to determine if somebody is an independent contractor or an employee. That standard can be found on our website, and that information will be at the end of this PowerPoint presentation. If you have individuals that you are paying as a 1099, it's in your best interest to look at the standard to make sure that they actually meet the independent contractor standard. If they don't, they are going to be considered employees and they will be covered by the earned paid leave law. Also exempt from the law are employees who are covered by a collective bargaining agreement that's in effect as of January 1st, 2021. Once that agreement expires, those workers will be covered by the earned paid leave law, and any subsequent contract should specify that. Also exempt will be employees who work in another state and don't perform any work or any service in Maine. So it may be a Maine business, but they have remote workers outside of the state of Maine that never actually physically work in the state of Maine. Those individuals would not be covered under Maine's earned paid leave law. Seasonal industries are, as defined in the Employment Security Act, are exempt from earned paid leave while those individuals are working within the established season. Seasonal employees, the criteria for that are the seasonal industry must be predefined as seasonal by the Unemployment Insurance Commission. The employer must have submitted an approvable determination of seasonal status to the Bureau of Unemployment Compensation, which identifies the seasonal period for the applicable year. If that criteria is met, then the employees working only within the seasonal period will be exempt from coverage under the earned paid leave law. And those particular workers would be covered by the earned paid leave law if they work outside of that established season. There are workplace requirements. The law does require that employers post information on the earned paid leave law in the workplace. That information is on this particular poster here, which all work environments should have, whether they fall under the earned paid leave law or not. These labor posters are provided free at no charge by the Department of Labor. They're on our website. You can download posters from our website. What you want to do is take a look at the revision date down in the bottom right corner to make sure you have the most current posters on site. This particular one was revised last month, so it has a revision date of 10/20. Again, the posters must be displayed. They've got to be in an area where employees can have access to them and can see them. They can't be locked in an office or put in a file drawer where an employee actually has to ask for them. Now, how do employees accrue earned paid leave? When do they start accruing leave? How much leave can they accrue? Does it roll over year to year? Does it need to be paid out when employment ends? Hopefully I can answer these questions as we go on. So a covered employee is going to earn 1 hour of paid leave for every 40 hours that they work. And they'll be entitled to accrue up to 40 hours in 1 year of employment for a single employer. Accrual, as I stated earlier, begins at the start of employment. Whatever that first day is that that individual performed a service for you is the start of the employment. No more than 40 hours of leave are required to be available for use during any 1 year period. Employers can have policies that provide a greater benefit without conflicting with the law. They just can't make it less than 40 hours. If the accrued leave is not used during the 1 year period, that leave is going to roll over and be available to that employee in the next year of employment. If the individual accrued 40 hours starting January 1st, by the end of the year, they accrued 40 hours, they didn't use any of it. January 1st of 2022, those 40 hours carry over. They're not going to accrue any additional time that year. It's just those 40 hours that they will be able to use in that subsequent year. If they used 8 hours and they carried over 32, they're only going to accrue 8 more hours in that second year. If the employee has accrued leave and they leave employment and the employer doesn't pay that balance out, if that employee returns to work for that employer within 12 months, that accrued leave is going to carry over to their new date of employment. If the employer actually has a vacation policy and the policy states that they pay the balance of unused vacation at the time of separation, and they don't have an earned paid leave policy, then any unused accrued earned paid leave at the time of separation is going to be required to be paid out. This law doesn't prohibit an employer from establishing separate policies for different types of leave. So you could have a sick leave policy, a vacation policy, and an earned paid leave policy. It would be in the employer's benefit to establish or create an earned paid leave policy so that that it's documented as to what happens to the earned paid leave at the time of separation. They can stipulate that it is not paid out. They can stipulate that it is paid out or that it's only paid out under certain circumstances. Whatever they establish for policy in their policy is what they are obligated to enforce or abide by. Notice and use of leave. So an employer can require notice for when an employee is going to use planned leave. The employer can require that the employee provide up to 4 weeks notice if they're going to use planned leave in advance. If it's an emergency, illness, or sudden necessity, the employer can't require advance notice, but they can require notice as soon as practical. The employer can restrict use of planned leave during certain times of year. They can have blackout dates. They can have restrictions as to the number of employees that can go out at any given time for operational needs. if they deny planned leave for a particular reason, they have to be able to show undue hardship. The burden is on the employer to show undue hardship for denying planned leave. Emergency leave, if the employee, pardon me, I think I hit a button there. If the employee is unable to, needs to use leave for an emergency illness or sudden necessity, they don't typically they're not typically going to have advance notice, so they have to provide notice as soon as practical. If an employee is going to work in the morning and they have car trouble, they notify the employer as soon as possible, saying, I'm going to be late because I have car trouble, and then they show up to work. The employer can require that they use any accrued earned paid leave for that missed time. They can require the use of earned paid leave in increments of at least 1 hour. They can't require the employee to use more than 1 hour of earned leave if they didn't actually, if they weren't out for more than an hour. So if the employee showed up to work 15 minutes late, the employer could ultimately say you need to use 1 hour of earned time for that. What they can't do is say you have to use a half day of earned leave. It can be in increments of 1 hour. If the employee is gives notice that they're out sick, the employer can't require a doctor's note unless the employee is out for 3 or more consecutive days. If they're out for less than 3 consecutive days, the employer can require a general description, I'm sick, or it was some sort of emergency illness or sudden necessity. It's a general description, but can't require a doctor's note. Again, I got ahead of myself there, but the employer can require that earned paid leave be used in increments of at least 1 hour. When an employee uses earned paid leave, they're going to be paid at their same base rate of pay that they received immediately before taking earned paid leave. In order to calculate that base rate of pay, the employer is going to have to take a look at the previous week and do a calculation. What were their total earnings for that, straight time earnings for that particular week, divided by the total hours worked to come up with the base rate. That calculation is also called the regular rate of pay. So the regular rate of pay is defined and established in the minimum wage statute. It basically says that all of your compensation, which includes your hourly rates, your per diems, your shift differentials, on-call pay, bonuses, commissions, those all factor in to the regular rate. They're going to factor in to the base rate as well. It's the same calculation. Total earnings divided by total hours worked, that's the average hourly rate, the base rate. That's the rate at which earned paid leave is going to be paid when they use it. For salaried exempt workers, the law doesn't require employers to keep daily time records on salaried exempt workers. If there is no daily time record, no salaried exempt workers are presumed to work 40 hours in a week. If there is a record, then you use that record. I know with state employees, regardless of the position you're in, you are completing a daily time record. If you are an employer that requires that, that's the record that you're going to use. If you're a worker in a service industry and you're paid on using the tip credit, meaning you get part of minimum wage plus tips to make up the other portion of minimum wage. If all of your rates of pay are using the tip credit, your actual base rate is minimum wage. And I'll get into a calculation here in a moment. If you have multiple rates of pay, you've got to figure out what is the base rate. Here's an example here where you have a worker that has multiple rates of pay. They work 15 hours at $13 an hour and 25 hours at $15 an hour. Their total earnings for the week was $570. You divide that by the total hours worked to come up with their base rate. In this case, it's $14.25 an hour. The next example involves service employees. Here you have an individual that works in a restaurant. They work part of the time as a server. They get $6.08 an hour plus their tips. They work part of the time as a host at $7 an hour, and also part of their time as a bartender at $10 an hour. Because all these rates are based on the minimum wage, as long as the tips and the direct wage being paid to them equals minimum wage at the end of the week, their base rate of pay is minimum wage. The law stipulates that the Bureau of Labor Standards is solely responsible for enforcing the earned paid leave law. What employers need to know is that each denial of paid leave could be a potential violation, which could carry a fine of up to $1,000 per violation. If there's an employer out there that refuses to allow their employees to earn or accrue earned paid leave, each of those employees is a separate violation. And like I said, the fine could be up to $1,000 each. So it can get pretty hefty relatively quickly. As I mentioned earlier, employers should consider creating an earned paid leave policy that outlines any notice requirement that they're establishing for the employee. So if they require a 4-week advance notice for planned leave, put that in the policy. If they require notice as soon as practical for any event that's an emergency, illness, or sudden necessity, put that in the policy. They should also put in the policy what happens to the unused balance of earned leave when employment ends, whether it gets paid out, whether it's not paid out, whether only a portion of it gets paid out under certain conditions. Whatever terms are established in that policy is what the employer is obligated to abide by. So here are some links. This PowerPoint will be on the website. You will be able to click on these links and access the information. You know, the unpaid leave laws in there. There's a very detailed frequently asked questions section. If you have questions, I suggest you review the detailed FAQs first to see if your question is in there. I think it's pretty comprehensive. So if for some reason your question, you don't see your question, you've got specific details, facts that don't relate in any of those questions, call our office, the number's listed here, and ask us. We'll get an answer for you. And I think that's it for the PowerPoint presentation. What I would like to do is answer any questions that you have at this time. I'm going to stop sharing my screen. And Christina, you can let me know if any questions have come in.
Right. Thank you very much, Scott. So at this time, I'll start to review the questions that have been posted in the chat, and then I'll relay them to Scott, Michelle, or Jeff for answering. We do ask that folks avoid asking questions that are specific to their individual business, though industry-related questions are just fine. But this is because a lot of those questions are often very fact-specific and require more of a one-on-one conversation and in-depth analysis that looks beyond the earned paid leave law. We also request that folks avoid questions that will have Scott doing any kind of mental math in order to appropriately and thoroughly answer the question. If you've already posted a question like this in the chat, please know that a copy of the chat record is saved, and I will reach out to you as soon as I can and connect you with the appropriate resource for your question. And so with that, the first question, Scott, is related to start of employment. The question is a drug test screening for a new employee considered the first day of employment?
It potentially is, if it's not part of the application process, and it's after the offer of employment is extended to the individual, it will be considered work time. So it would be, their start of employment would be the time that they go in to get that or submit to that drug test.
Thank you. Next question is, will there be any reporting requirements to the Maine Department of Labor? Hours that an employee earns, uses throughout the year, or is it only an internal reporting by the business?
Nope, it's an internal reporting. What you do need to know is that the employee is going to be keeping track of, a lot of employees are going to keep track of their own hours, so they should match up with what you as the employer have. The requirement to provide a detailed pay statement, the labor law that requires a detailed pay statement also requires hours worked be listed on that pay statement, with the exception of salaried exempt employees. But employers are not going to be required to report number of hours worked to the Department of Labor on a regular basis. If we get a complaint or need to investigate a complaint, we will look at what you do have for a record of hours and make sure that you are in compliance.
Thank you. Is there a requirement that this policy be separate from our current PTO policy?
No, as I stated earlier, if you don't establish an earned paid leave policy, you have a PTO policy. If your PTO policy specifically states what happens to the balance of PTO when employment ends, or you've had a practice of paying it out when it ends, then it will need to be paid out. The earned paid leave balance would need to be paid out at that point. That's why it's a good business practice to establish a specific earned paid leave policy that dictates what happens to the earned paid leave separation, what type of notice requirements you expect. Documentation is an employer's best friend.
Thank you. Can we offer to pay out each year, or does the earned paid leave that has not been used have to roll over?
You can offer to pay it out. You can't make it a requirement that it will be paid out, or that it must be paid out year after year. If the employee wants to have it paid out at the end of the year, you can make that decision if you're going to pay it out or if it's just going to roll over. You just can't dictate that it has to be paid out.
Thank you. So you gave an example earlier of a situation where someone carries over 32 hours from 2021, stating that they would only accrue 8 additional hours in 2022. So if in 2022 they used all of those hours, can they accrue additional hours?
The law doesn't require additional hours be available. That would be at the discretion of the employer. The law just says that the employee must be able to accrue 1 hour for every 40 hours worked, a maximum of 40 hours. So if at the beginning of the year they carried over 40 hours, they're already at the maximum. The law doesn't require additional earned time in that particular year.
Thank you. If a current policy only allows half carryover, how would this new policy work with this situation?
Yeah, it wouldn't be in compliance. The current PTO policy would not be in compliance with the earned paid leave law if you limit the amount of time that can be carried over if it's less than 40. If they have 40 and your policy says you can only carry over 20, that would conflict with the law.
Thank you. How does earned paid leave work with other types of leave such as FMLA, and does it run concurrent?
So the earned paid leave can be used for an individual that's out on FMLA. What the law specifically states is that an employee can't lose any existing benefits because they're using earned paid leave. So if you have a sick leave policy, a vacation policy, and you're creating a separate earned paid leave policy, bank of time, if they use 8 hours of earned paid leave, the employer can't say, well, you're also going to lose 8 hours of sick or 8 hours of vacation, or you're going to lose your health benefits. But the first 40 hours that an employee is unable to work, whether they show up late or have a planned vacation, the first 40 hours can be applied to the earned paid leave. And then anything beyond that, an employer can establish their own thresholds or restrictions.
Thank you. And so kind of on a similar train of thought, how does this work, or how does this work with short-term disability?
I'm not sure with how that's going to work. I can tell you that an employee can use earned paid leave if they're out on short-term disability. It's not going to conflict with labor law if it's at the request of the employee. If the employer requires the individual to use earned paid leave while they're out on short-term disability, I may need to think a little bit on that to come up with to get a answer for you.
Thank you. So Monica, we will follow up with you on that later. The next question is, if an employer's PTO policy already in place allows leave to be taken in increments that are less than an hour, does that have to apply to earned paid leave, or can the employer separate requirements and require increments of 1 hour for this specific leave?
Yeah, I do apologize. I was making a note to myself on that last question when you started that question. Can you repeat that?
Oh, yeah. Sure thing. Sorry about that, Scott. The question is, if an employer's current PTO policy already allows leave to be taken in increments of less than an hour, does that have to apply to their earned paid leave as well, or can an employer specifically require increments of 1 hour for earned paid leave?
No, the employer can require increments of 1 hour for earned paid leave.
Thank you. The next question is, annually we offer 120 hours of vacation and also 120 hours of sick as separate plans. Since we provide well over the requirement of paid leave for this policy, can we keep our policy as it is, or do we need to create a whole new policy?
Well, that's going to depend if that 120 vacation and 120 sick is front loaded, or if they accrue it over the period of the year. If it's accrued, it must be accrued at the rate of at least 1 hour for every 40 hours worked. The first 40 hours that are paid out, whether it's vacation, sick, or a combination of both, has to be at the base rate of pay using the calculation I mentioned in the PowerPoint. By looking at the previous week, what were the total straight time earnings, divide that by the total hours worked to get that base rate of pay. If it's meeting the accrual rate and the payout rate for the first 40 hours, it will probably meet the earned paid leave requirement.
Thank you. Could you speak a little bit to how you would calculate an employee's base rate of pay based on commission?
Yep, the commissions and bonuses are usually paid out on like a deferred basis. They're paid out at intervals that are different than the normal pay cycle. If you're paid weekly, you typically aren't going to receive a weekly bonus or a weekly commission. It's either paid on a monthly basis or a quarterly basis or a annual basis. The commissions or bonuses can be prorated to apply to the period of time, prorated for the period of time to which they apply. If it's paid on a monthly basis, divide that commission or bonus by the number of days in the month. That gives you the daily rate. You look at the week prior to the employee taking earned paid leave and apply that amount, adjust their earnings to include that amount, make the calculation, divide the division to get the base rate. I don't know if I confused people when I just said that, but I think we do have a FAQ, or we're going to have an FAQ on commissions and bonuses and a sample example.
Thank you very much. Is it correct that overtime premium is not required in the base rate calculation?
Correct. Overtime is not included in the base rate. It's straight time earnings per hours worked and any subsequent compensation that they receive, such as shift differentials, commissions, bonuses that can be prorated for that period of time.
Thank you. If our policy requires that shifts be worked before and after a paid holiday, if the employee is using earned paid leave before a holiday, would that preclude the company policy?
So the policy is that you have to work before and after a holiday. I guess I don't understand what the question is. If the employee has accrued earned paid leave and they meet your notice requirements and they use earned paid leave, I guess I don't know ultimately what the question is.
And that might be a question we want to revisit verbally when we wrap up in the chat.
Yeah.
And the next question is, if a salaried worker uses leave in February and then receives a bonus in June, do we need to recalculate their regular pay and reimburse them the difference?
Yes. Yeah, if the bonus is deferred, you then prorate it for the period of time to which it applies. You look at any week where the employee used earned paid leave, and then you make an adjustment to their pay for those days.
Thank you. Next question touches on something we just discussed, but it is, if our current PTO rate does not include bonuses and shift differentials in calculation, we will have to do this differently for EPL calculation and track it separately, question mark.
Correct, for the first 40 hours.
Thank you. Could you please address whether or not call firefighters are covered by this new law?
Right. Call firefighters, if they meet the exemptions that are in 1043, there's specifically there's actually two exemptions that come to mind. One is regarding volunteers that receive a nominal stipend, and I think I need Michelle or Jeff to help me with what the other one is. But if they meet either of the exemptions that are established in the employment standard 1043, then they're exempt from earned paid leave. If those call firefighters don't meet either of those exemptions, then they are entitled to earned paid leave.
Thank you. If current policy allows salaried employees to only use half-day or whole-day increments of PTO, are they now able to use a 1 hour increment with earned paid leave?
Yes. Yep, the employer can't require the employee to use more than 1 hour if they were not out for more than 1 hour.
Thank you. Does straight time include hours paid the week before and overtime rate, or just total hours worked divided by current pay rate?
Okay, so you're using straight time earnings. The total straight time earnings divided by the total hours worked. So overtime is time and 1/2. Okay, so you're still considering if the person worked 45 hours, they get 45 hours of straight time and then 5 hours of half time. You're paying, you look at the 45 hours divided by the straight time earnings, that will give you the base rate.
Thank you. This is a confirmation. So just confirming that each employee must earn 1 hour for every 40 hours worked, no matter what our current policy states. An example is an employee that has an accrual rate of 0.031 per hour. So if this were the case, we wouldn't be in compliance, correct?
Okay, so the law, the earned paid leave law is the floor. The minimum amount must be at least 1 hour for every 40 hours worked. If your current policy isn't meeting that threshold, you do have to change it. If it's exceeding it, there's no problem.
Thank you. This one is, so to clarify, an employer can use their established PTO policy and then create a separate earned paid leave policy using the law's guidelines. And if the employee no longer qualifies for the established PTO, but then begins accruing time under the earned paid leave policy, which accrual should be used first? Regularly established PTO or earned paid leave? And can the employee dictate to the employer which they would like to use?
So the earned paid leave law should apply to the first 40 hours that any employee takes off. So if you have an existing PTO policy, you should apply the earned paid leave standard to the first 40 hours. Anything after, in excess of 40 hours, your existing policy can be, is fine. There won't be any conflict with the law.
Thank you. The next question is, if you are hiring seasonal employees, but you are not a seasonal business, would they accrue earned paid leave?
If you hired seasonal employees, but it's not a seasonal business, yes, they would accrue earned paid leave. There are businesses that ramp up staff during particular times of year. Retail establishments may ramp up their staffing during the holiday season. Those aren't, if it's not an established seasonal industry and you're not operating within the established seasonal period, it's not deemed seasonal. Therefore, earned paid leave will apply.
Thank you. Would straight time also include a $20 crew chief stipend?
A stipend is compensation. Stipend is typically going to be included in the calculation for the base rate.
Thank you. So this question is just double checking. Salaried staff can be asked to use time in hour increments, ? Does this conflict with the basis of exempt workers? If they work part of a day, aren't they to be paid for the full day under exempt laws?
Right, so there are, to be an exempt salaried employee, there's a 3-part test that has to be met to be a bona fide exempt salaried employee. They're paid on a salary basis, they're paid a minimum salary, and they pass the duties test. They're performing work in an executive, administrative, or professional position that's defined. If a salaried employee works part of the day and they take the rest of the day off, they still have to get their full salary. What the employer can do is require the employee to use any paid time off that they have, earned paid leave, vacation, sick, whatever it may be, to make up that difference. If the employee has exhausted all of their paid leave and works part of a day and takes the rest of the day off, the employer is still obligated to pay the full salary.
Thank you. If a current policy only allows a half carryover, which in this case is 32 hours, with this new law, would people be required, or would employers be required to allow a 40-hour carryover?
Yes, the law, it's a minimum of 40 hours, or maximum, I should say, 40 hours. If the employee has accrued 40 hours of earned paid leave and they don't use it from one year to the next, they've got to be able to roll that 40 hours over.
Thank you. So when you say that this law should apply to the first 40 hours, does that mean in a calendar year? So for example, commissions wouldn't need to be calculated into the base rate of pay after the first 40 hours are taken in a calendar year, ?
Right, so if the employee used 40 hours of earned paid leave in the first half of the year, and then at the end of the year, they received a commission for the second half of the year, a recalculation is not needed for those first 40 hours. I think that's how I'm understanding the question. If the employee has used 40 hours and then they receive a bonus or commission after using those 40 hours, and that bonus or commission doesn't apply to the period of time where they used those first 40 hours, no recalculation is needed.
Thank you, Scott. So this next question is about the 120 days and also seasonal employees. So we are not a seasonal business, but we do hire seasonal employees. Most will not be employed for 120 days by the time the season ends. Some employees could return over the holidays and work a few more hours. We generally do not know until the following spring if a seasonal employee would return for the summer or not. It seems we could wait until they are termed before paying out time they accrued, even if the time they earned was in the previous year.
I'm not quite sure what you're asking, but let me try to clarify. You hire somebody for a particular period of time. They work less than, they've been employed for less than 120 days and their employment ends. They would have accrued leave, but they wouldn't have been necessarily eligible to use it because they hadn't met the 120-day threshold. If they come to return to work for you within 12 months, that earned leave that they had accrued is going to carry over and they'll be eligible to use it going forward.
Thank you. If for employers that ensure all employees have 40 or more hours available on January 1st of each year, do they satisfy the carryover requirement and the time off provisions?
Yeah, if the employer front loads 40 hours each year, it's meeting the minimum threshold, and they're not going to be required to roll over those unused 40 hours to the new year, so they have 80 hours. If it's just 40 hours, it could be a use it or lose it in that scenario up until the point of separation. And if they worked for a number of years, they had the 40 hours advanced to them each year, and they either use it or didn't use it. In the last year, if they didn't use it and they got done, they would have to get paid the prorated amount for which they would have accrued by the time that they leave employment.
Thank you, Scott. So for employers who have separate PTO policies versus earned paid leave policies, would that employer need to change their PTO policy to accommodate for this 40-hour carryover, or can a separate policy be created for earned paid leave? And so the example here is that they currently allow 32-hour week employee to carry over 32 hours at the end of the year. Is their PTO policy still able to do that if they then have a separate policy with carryover of 40 hours for earned paid leave?
Yeah, current existing policies are fine if you establish a earned paid leave policy. So in this particular question, the PTO policy doesn't have to be changed. You're creating an earned paid leave policy that's meeting the minimum requirements of the law. You'd be in compliance.
Thank you. And then the final question in the chat before we open it up to verbal questions is, I'm confused about the bonus issue and having to go back and recalculate anything. I thought we just needed to look at the previous week's total pay to determine the rate when it is asked for, when it is asked to be used.
Right. The law requires that earned paid leave be paid at the base rate of pay. The base rate of pay is defined as the regular rate, which is also defined in the minimum wage statute. If you, in examples where employees, before earned paid leave, where employees work overtime and they get a deferred bonus or commission, employers have always been required to do a recalculation on those weeks where the employee worked overtime to account for that additional compensation that applies to that period of time. The same thing is going to apply to earned paid leave, with the exception of you're not doing it because of overtime, you're doing it because they used earned paid leave, and earned paid leave requires that it be paid at the base rate of pay.
Thank you, Scott. And I would just like to bring up to folks, as Scott mentioned, we are creating an FAQ on bonuses as well as other rates of pay. And so when that FAQ is updated, I will send an email out to everyone on this list, just letting them know, as well as attaching that updated FAQ document. And so with that, would anybody like to ask a verbal question? If so, please raise your hand or send me a private message and I will unmute you. Oh, quick question, Scott, are Christmas bonuses included in this calculation?
Okay, so if the bonus is not paid for, if it's not announced in advance and the employee is not working to reach a goal, then it would be considered a discretionary bonus. So if this is a bona fide discretionary bonus, the employer decides without announcing to their employees, hey, I'm going to give a bonus to employees this year because we did so well, or just because of the type of year that we had. If it's truly a discretionary bonus, that bonus is not factored in to the base rate of pay.
Thank you, Scott. And so we do have a verbal question from Cindy Barnacle. I'm just going to try to find Cindy in the group and unmute her. And Cindy, you should be good to go.
Great, thanks, Christina. Hi, Scott. Thank you for all your information today. So I've been asking some of the questions about deferred bonuses, and I'm curious if I have two questions. Number one, do they apply to salaried workers? So that's my first question. And number two, if you pay a bonus to a salaried worker, say in the spring of the following year, do you have to do any recalculations if they used leave the prior year?
Right, so the bonus paid to a salary worker is going to affect their base rate for the first 40 hours of any leave that they take. So you would have to do a recalculation for that. Same with if you pay the bonus in the following year, if that bonus applies to a specific period of time, you would look at that specific period of time and prorate it for any week or any time that the employee used their first 40 hours of paid leave.
Great. So if we're looking at 2022, say, and a salaried worker uses 40 hours of paid leave in 2021, and then they get a bonus in 2022, you need to back pay them for the paid leave in 2021?
Yes, if that bonus paid in 2022 applies to all of 2021,
Right.
yep, you would look at specific weeks where the employee, the first 40 hours of paid leave used in 2021.
Great. Salaried or exempt or non-exempt?
Yes, both.
Thank you so much.
You're welcome.
All right, and so we have a hand raised by Laura McPhail. So Laura, I've just given you the go ahead to unmute. All right, so while we wait, a question came in from Angela Rahman. Per diem employees that are not independent contractors are still eligible for earned paid leave, correct?
Correct.
All right. Are there any additional questions? Oh, looks like Laura is unmuted. Go for it, Laura.
Yeah, sorry about that. Yeah, let's see if I can articulate this. So I had the question about having the policy where employees are required to work the shift before and after a holiday in order to be entitled to the holiday and it being a paid holiday. They can take vacation time either before or after a holiday, but they can't call in sick. So I'm thinking that with this paid time off that we'd have to change that policy if they were using the Maine earned paid leave.
No, not necessarily. So
Okay.
for your example, the holiday where they've got to work the day before and the day after, in order to get paid for the holiday that they don't work on, there's no requirement in labor law to pay an employee for a holiday that they don't work on. That's at the employer's discretion. Okay. What you would have to do is if they called out sick or used a planned vacation a day before or a day after, you would have to pay the earned paid leave. Whether you pay the holiday pay or not is at your discretion.
Okay, because I thought there was something in there about it not using the time couldn't affect benefits that they would normally get. And I'm thinking, okay, the paid holiday is, I wonder if that falls in that category, but it sounds like it doesn't.
Right, it doesn't fall under
Okay.
that category.
Thank you.
Thank you, Laura. All right, so we have time for one more question if there's anybody who'd like to ask a verbal question. Oh, and I do see two in the chat. So this one is, when talking about bonuses, would this include bonuses received as part of a performance evaluation or salary increase, not tied to a specific goal? So would that be considered discretionary, or would that need to be calculated into the base rate of pay?
So I think I would need more detail. As to what that bonus is, and may require me speaking with you directly. I don't know if you can get that information, Christina, or
Absolutely.
not, or just pass on my number to her, to the person asking the question.
Perfect. So Elizabeth, I'll reach out to you shortly. And then final question is, if an employee is allowed 120 hours of vacation, they must be able to carry at least 40 hours because of earned paid leave. So does that mean they do not earn any more earned paid leave the following year because they already carried over that 40 hours?
Right, so if they get 120 hours front loaded and they use 40 hours during the year, there's no requirement to carry over any. That would be an employer at the employer's discretion to carry over anything additional. And what was the second part of that?
That answers the question, I believe.
Okay.
Yep. And then just one more confirmation is the bls.mdol@maine.gov the best email for folks to use with questions?
Yes.
Excellent. All right, thank you, everyone. At this point, I'll turn it over to Mike Rowland to close us out.
Oh, thanks, Christina. Yeah, so just as we were just reminded, we're available for individual questions, like for instance, the more fact-based questions that Scott really should answer one-on-one, but we're here to answer those. We're also adding constantly to our facts, our frequently asked questions and answers. We've managed to harvest a good number of those questions during these sessions, and I think we have a couple more from today's session that we will answer and post on our frequently asked question page on our website. I hope people will be able to access this PowerPoint. I think there was a little trouble before, but I was able to access it, and I'm sure that we'll be able to make it available to you. We'll figure out what the problem was. And then just beyond that, thanks everybody for participating. Thanks particularly to Scott for his magnificent ability to field questions and provide good answers, and to Christina for running the show. Thanks everybody, and be well.
Thank you very
Thank you,
much.
Bob.